Good day, Canada. Good evening, Asia. It's Thursday, 12 p.m. here in Toronto, and it's time for a regular webinar on immigration and visas to Canada. My name is Alex Davidson, and our topic today would be about bringing family to Canada. We'll explain how family sponsorship works, who's eligible to be a sponsor, and what relatives could be sponsored to Canada. Let's reiterate how a family is defined in the Canadian immigration legislation. Generally speaking, in any immigration case, a family consists of the primary or principal applicant, his or her spouse, and their children under 19 years of age. Please note that until the recent time, the age limit for dependent children was 22, and there was one notable exception under which a child considered dependent even if he or she was over 22 years old. But at the same time, say he or she had been financially dependent on the parents, that was still considered to be dependent. Since August 1st, 2014, things have changed. A child must be 19 or to be considered a dependent, and even if he or she is a full-time student of 19 and over, this does not have effect any longer. So the first and the most obvious way to bring your family to Canada is to apply for permanent residence. All dependent family members receive permanent resident status together with the principal applicant. The other way to bring family members to Canada is called family sponsorship, and here's how it works. Family sponsorship class consists of three different programs. First is for sponsoring spouses and common law partners to Canada. Second is for sponsoring children, and the third one is for sponsoring other eligible relatives, including parents and grandparents. So today we'll talk about the first and the third one. In many cases, family sponsorship is called family reunification. While this isn't an official name for this immigration class, its very well, I believe, reflects its purpose to make families reunite and live together in Canada. Let's now talk about each of the two sponsorship programs in more details. So family sponsorship program for spouses and common law partners is also called spousal sponsorship. This program is designed for a very common scenario when a Canadian citizen or Canadian permanent resident, he or she enters into marriage or common law relationship with a foreign national. So when he or she is visiting Canada, I mean the foreign national, or when the other party is visiting countries outside Canada. So as a result, a new family is created where one of the spouses is Canadian while the other is not, which prevents the family from living together in Canada. Of course, the family is free to relocate to any other country, but Canadian legislation protects the interests of Canadians. And in this case, it gives them the mechanism of bringing spouse to Canada as a permanent resident. Now, there are two situations possible in the given scenario. First is when a spouse is in Canada as a temporary resident or can come to Canada temporarily by having a visa or citizenship of a visa-exempt country. Second one is when a spouse is outside of Canada and cannot come to Canada, simply because he or she does not have temporary visa or is unable to receive one. According to the situation, spousal sponsorship can be initiated either in Canada or outside. If a spouse cannot come to Canada, the choice is obvious. Sponsorship can only be initiated outside of Canada, and the application would be processed by a Canadian visa office abroad. However, if a spouse has a visa to Canada or is a visa exempt otherwise, either option is possible. So when choosing which sponsorship process to begin, inside Canada or abroad, one has to take into account the following. First, spousal sponsorship processing times in Canada can be longer than abroad. But this much depends on the workload of Canadian visa officers abroad, and for some countries, processing times are on par with processing time in Canada. Second thing to consider is spousal sponsorship when it takes place in Canada. The spouse being sponsored is eligible to receive a work permit, thus being authorized to work in Canada and to legally contribute to the family budget. Naturally, sponsorship outside of Canada does not offer this opportunity. Third factor, that if a negative decision is made in a spousal sponsorship application in Canada, this decision cannot be appealed via the Immigration and Refugee Board, which means that the refusal can only be appealed by the federal court. At the contrary, if a spousal sponsorship takes place outside of Canada, a negative decision can be appealed via the Immigration and Refugee Board without the need to file the application to the federal court. Fourth, if a sponsorship takes place in Canada, the spouse has to maintain legal temporary status in Canada during the entire immigration process, or otherwise he or she has to leave Canada. This means that the new family gets separated, which in turn may introduce some difficulties in terms of supporting genuineness of family relationship, especially if the entire process is very long. Just imagine yourself in place of an immigration officer. An application in front of him or her states that a Canadian is sponsoring husband or wife, but at the same time it's clear that after some period of cohabitation, they got separated for a long period of time. We are often asked about what requirements a Canadian must meet to be able to sponsor a spouse from abroad. So here's the answer. A sponsor must be a Canadian citizen or a permanent resident in Canada. A Canadian citizen sponsoring his or her spouse or common law partner can either be in Canada or outside, say in his or her fiance's home country, during the process of sponsorship, of course. However, if a sponsor is a permanent resident of Canada, he or she is required to be in Canada for the sponsorship to be made possible. Next requirement is of utmost importance. The family relationship should be absolutely genuine. So the couple has to satisfy an immigration officer that their family union is not a so-called marriage of convenience, a collusion serving the sole purpose of obtaining permanent resident status in Canada for one of the spouses, most often for a good amount of cash money paid to the sponsor. Therefore, the most important task of an immigration officer processing the spousal sponsorship application is to determine if a relationship is genuine or not. There are numerous tricks and techniques used for this purpose, from careful examination of wedding photos to a sudden visit at a family home to see how the couple is living together. This extensive topic is, however, outside of the scope of the webinar today, and we'll probably talk about it next week. As for the financial aspect, there are no strict financial requirements when sponsoring a spouse or a common law partner. While it's advisable for a sponsor to be employed and have some income and savings, it's not absolutely mandatory. There is also a difference between supporting documents for sponsoring a husband or wife after marriage and for sponsoring a common law partner when a family union is not officially registered. In the first case, a marriage certificate serves the primary purpose of sponsoring family support and family sponsorship. Other factors are taken into consideration. So, for example, how long the couple has been living together, are they compatible in terms of age, cultural and social background, and so on and so on. Everything is important if it helps an officer to understand a marriage is genuine or not. In the second case, when we're talking about common law partnership, the marriage is not officially registered. Therefore, other document evidence is required to satisfy an officer that the couple is living as a family. Examples of supporting documents are joint tenancy agreements, joint bank accounts, mutual life insurance, proof of vacation trips together, and so on and so on. If a couple has children, it speaks in favor of their genuine relationship, but it's still not a sufficient fact by itself. Therefore, other supporting evidence is not to be neglected, of course. That is basically all you need to know about spousal sponsorship, as much as our webinar allows us to explain. Now, let's proceed to another sponsorship program that allows to sponsor other eligible relatives, including parents and grandparents, to Canada. Some examples of relatives eligible to be sponsored are a brother or sister, a nephew or a niece, grandson, granddaughter, if he or she is an orphan under 18 years of age and not married, or in a common law relationship. Any other person, regardless of age, with whom you have a family relationship, if you do not have a spouse, common law partner, conjugal partner, son, daughter, mother, father, brother, sister, grandfather, grandmother, uncle, aunt, niece, or nephew, who is a Canadian citizen. A registered Indian means First Nation, of course, a permanent resident. We'll show how the sponsorship program works on one example of sponsoring, say, for example, parents to Canada. Let's again get back for a second to the eligibility requirements for a sponsor. They are different from what we discussed above for sponsoring a spouse or a common law partner, because simply now we're talking about sponsorship of individuals of a retirement age, right? We're talking about parents most of the time. So since it's unlikely that they will work in Canada generating income and paying taxes, the approach here is different. In addition to being a Canadian citizen or permanent resident, the sponsor must also meet the so-called low income cutoff requirement, or also shortly called LICO. As the term implies, these criteria filter sponsors by their income, because the stable and sufficient income is absolutely required to support elderly parents in Canada. Here's a few facts and figures about the low income cutoff. First of all, the income threshold is not a fixed number applicable to each and every parental sponsorship application. It's obvious that a single Canadian sponsoring his or her single mother to Canada will have much less combined financial burden than, for example, a family of 4 sponsoring 2 parents at the same time. Therefore, the LICO depends on the size of the sponsor family and on the number of persons being sponsored. For example, a single Canadian sponsoring a single parent must have yearly income of about just 38,000 Canadian dollars, while a family of 4 sponsoring 2 parents must have income of $72,000 and above. These figures are so-called gross income, in other terms, the amount of income before income tax is paid. There is no other way to prove the income but to provide the official notice of assessment. That is the document provided to every Canadian taxpayer by the government authority, Canada Revenue Agency or CRA. This document is provided after his or her annual tax declaration is received and processed in Canada. So simply put, a sponsor must work in Canada or have other sources of official income and pay his or her taxes in Canada to be eligible to sponsor parents from abroad. It's not required, however, that a sponsor alone is to generate the income. If a sponsor is married or live in a common law union, his or her spouse or common law partner can be a co-signer on the sponsorship application, this way contributing to the total income assessed against the LICO. The income itself must not be just sufficient, but should also be stable. Therefore, the income for the last 3 years is always assessed. Moreover, since processing sponsorship application takes time, the sponsor must meet the LICO requirement during the entire sponsorship process until the day his or her parents are granted permanent residence in Canada. It often becomes his or her legal responsibility to support sponsored parents financially for as long as 20 years. So if you decide to sponsor someone in Canada, be absolutely assured that you would have to support your parents to do that, to live in Canada. Now, to conclude our topic today, we'll touch upon a few figures illustrating the current situation with the parental sponsorship in Canada. As you may know, since the early 2000s, Canada accepted a large amount of potential sponsorship applications that created a huge backlog by 2011 because simply CIC was physically unable to process each received application on time. So as such, while in 2002 processing time for parental sponsorship application was between 2 and 3 years, in 2011 it grew up to about 8 years, which is absolutely unacceptable for many applicants given that parents being sponsored are elderly people. So measures were taken by CIC in 2011 when the backlog reached more than 165,000 of applications. And today the backlog was reduced to just about 50,000 applications in queue. So every year, Canada welcomes about 20 to 25,000 parents as permanent residents with the approval rate as high as 85% and even above. The processing time is expected to be less than 3 years today. And the very last note today on the family sponsorship. All I told you before is applicable if a sponsor is residing in any province of Canada except for the province of Quebec. So just to remind you, Quebec has the special agreement with the federal government allowing the province of Quebec to administer its own immigration programs, including family sponsorship. So Quebec has own requirements when it comes to sponsorship, sponsoring relatives from abroad. Simply come to us if you need assistance with Quebec sponsorship application, and we will help you, of course. As I always repeat in the end of each webinar, if you're looking to assess your chances, see how you may immigrate to Canada, how you may bring your relatives in here. You generally have two major ways to do that. You may contact our trusted team in Bangladesh, Visa Center, or to come to us directly. Visa Center is our local foothold, local team who supports applicants and helps us all to assist you in legal immigration ways. Please also feel free to check our YouTube channel where we have all the previous webinars absolutely free for every applicant. Please give us your like, or +1, share our presentations. It is important both for me and for our Bangladesh team. The more people would know about legal immigration ways, legal programs offered by Canada, the lesser there would be the chance that anybody would be cheated or defrauded by local firms. Next Thursday, we would, of course, continue speaking about family sponsorship, and we would cover a very specific subject of proving your relationship for spousal sponsorship. Thank you all for listening to me today. Stay tuned, and on this note, goodbye.